Okay, I'm going to call this meeting to order. It's 3 o'clock. So welcome everyone. We're here together today to learn about applications for minor variance and consent applying to certain lands in the municipality of Meaford. I'll start by introducing members of this committee and staff. I'm Linda Van Alst. I'm vice chair of this committee. Our chair has sent regret. She is not well today. We also have committee members Terry Williams, Lynn Whitbeck, and Ed Ormsby. Our planning staff in attendance include Denise McCarl, acting secretary treasurer for this committee and manager of planning services, Margaret Potter, a planner with the municipality assisting with secretary duties, Meredith Gillespie, planner for the municipality, and I believe John Douglas, who is our consulting planner for the municipality, is joining us by Zoom. Is that correct? While this committee is legally required to make decisions that conform to the county and local official plans, the Planning Act, and municipal policy and procedures, encourage us to reach out to you, members of this community, to hear your thoughts about the proposed application. Your constructive comments will help us to learn more about your neighborhoods, which in turn will help us to make informed decisions. Those who have pre-registered for today's meetings or are in attendance will have an opportunity to speak. I will call on you at the appropriate time. You do not have to be solely in support or opposition. It's okay to share your thoughts about those elements that you do and don't like about the proposal and to ask questions as well. The applicant will have an opportunity to respond to questions and comments raised. Anyone who wishes to receive notice of any decision on any of the applications being heard today will need to contact the Secretary Treasurer by email at planning@meaford.ca or by phone at 519-538-1060, extension 1120. I'm going to call disclosure of pecuniary interest in the general nature thereof. Seeing none, I'll read the land acknowledgement. We would like to acknowledge that we are meeting on the traditional lands and treaty territory of the Saugeen Ojibwe Nation, which includes the Chippewas of Nawash unceded First Nation and the Chippewas of Saugeen First Nation. We also recognize the Métis whose ancestors shared this land and these waters. We extend our gratitude to all Anishinaabe and Métis people and their descendants, past, present, and future, who continue to care for and inhabit these lands and tend these waters. Okay. I have only done this, I think, once before, so bear with me as we go through this. I'll call for the adoption of the previous minutes. Could I have a mover? Lynn, seconder? Ed, any discussion regarding the minutes? Seeing none, I'll call for the vote. All in favor? Thank you. Terry's, you're abstaining because you weren't here. Okay, right into our public meetings. This is a meeting of the Committee of Adjustment to consider an application for minor variance under Section 45 of the Planning Act for lands known as 193 Butcher Street, East Meaford, in the municipality of Meaford. The requirement to hold this meeting is that there must be at least 10 days notice as prescribed by the Planning Act. Margaret, please confirm that public notice was provided at least 10 days prior to this meeting.
Yes, notice was given on August 8th, giving more than required 2 days.
Will you please summarize the application and provide us with any comments that have been received concerning this proposal?
Yes. Just pulling out some comments that were just received. Oh, that was okay. Just confirming. Sorry about that.
That's okay.
So application A12/2022 is to facilitate the construction of a new detached dwelling. A variance is requested to allow a 3.8 meter front yard setback, whereas section 6.2 of the zoning bylaw requires a 7.5 meter front yard setback. The applicant also requests a variance to permit a front porch that encroaches into the required front yard by 1.8 meters and more than 50% of the required yard. Whereas section 4.6 of the zoning bylaw permits porches to encroach into the required front yards by no more than 1.5 meters and no greater than 50% of the front yard.
Okay.
This application, comments have been received from 2 members of the public, John R. Earl and Trevor Hessel, and agencies being the Grant County and Historic Society Métis, all with no concerns or recommendations.
Thank you. John, are there any additional comments regarding the file?
Hi
Is
there.
John there?
Yes. Can you hear me?
We can hear you.
Okay, I was worried there because I was looking for unmute and I couldn't find it, and then finally it just popped up on the screen. Anyways, no, I have no additional comments. Everything was described just fine.
Thank you. Has each member of the committee visited the subject lands, and does any member of the committee have comment with respect to their site visit or with respect to the application? Terry?
Just one small question. The map does not indicate where the existing porch line is. Is the new porch any closer to the street than the old porch of the existing house?
Who would like to answer that? John?
Okay, there, I think I'm unmuted. Yes, I believe that it actually improved the situation slightly. So it's not worse than the situation was previously.
Thank you.
Okay, any other comments or questions? Is the applicant or their agent here for the application present, and do you wish to speak to the application? If you could come up to the podium and state your name.
My name is Judy Prima, speaking on behalf of the and I want to thank you in terms of the porch question section, a little further back than the existing one. And I want to, if anybody has any questions, I'd be more than happy to answer them.
Okay. Anybody have any questions for Judy? No? Okay, thank you. Margaret, can you please provide us with the suggested decision and conditions of the variance?
Certainly. So the suggested decisions that the Committee of Adjustment grant the minor variance application, and with the condition that the proposed new dwelling be set substantially in accordance with the sketch.
Thank you. Can I call for a mover? Jerry, seconder? Ed, any discussion? Seeing none, I'll call for the vote. All in favor? Okay, that's carried. Thank you. I'll just wait till everyone has signed the motion before we move on. Okay, this is a meeting concerning application A13-2022, a meeting of the Committee of Adjustment to consider an application for minor variance under Section 45 of the Planning Act for lands known as 217 Boucher Street, East Meaford, in the municipality of Meaford. The requirement to hold this meeting is there must be at least 10 days notice as prescribed by the Planning Act. Margaret, can you confirm that 12 days notice was given?
Yes, notice was given on August 12th, giving more than required notice.
Thank you. Will you please summarize the application and provide us with any comments that have been received concerning the application?
Sure. Through application A13-2022, the owners are proposing to build a second-story addition on the south side of their existing house. The owners also propose increasing the volume of the existing second floor at the north side of the house. They also propose to demolish the existing front porch and build a new front porch along the north and east sides of the house. The owners request minor variance from the bylaw to allow the porch and dwelling to encroach into the required front and exterior side yards, allow a 5-meter encroachment of the front porch into the front yard. This amount includes the house dimensions, and a 2.1-meter encroachment of the porch into the exterior side yard, and to encroach by more than 50% of the required yard, whereas porches may currently encroach into required yards by no more than 1.5 meters and no greater than 50%. Also to allow a 3.8-meter front yard setback for a second-story addition, where 7.5 meters is the required front yard setback, and to allow a 1.4-meter exterior side yard setback for a second-story addition, where the zoning bylaw requires 4 meters. These setbacks would allow the second-story additions to be in line with the front and exterior side walls of the existing dwelling. Comments have been received with no concerns or recommendations from Grey County, the Historic Society of 19, and the Conservation Authority, who do note that the proposed construction is outside of the regulated area.
Okay, thank you. John, do you have any other additional comments regarding this file?
Hello. Yeah, I don't. I guess I'm more than willing to answer questions. This is a challenging one because the lot is irregularly shaped. So the setbacks were a bit of a challenge, and just looking at where the previous porch was and the proposed porch is sometimes a little difficult to see. So if anyone has any questions with respect, I'd say the Appendix 2 certainly would help if you had any questions on with respect to specific setbacks and where the existing was and where the proposed is.
Okay, thank you. Has each member of the committee visited the subject lands, and does any member of the committee have a comment with respect to their site visit or with respect to the application? Terry?
I guess my question is there any legal precedence to cancel the easement across Part 2?
Be a question for you, John.
Yeah, no, that's a challenging one. I'm not a lawyer. I don't know if I'm not certain, to be honest with you on that. I'd be cautious because it sort of steps outside the realm of planning into a legal question.
I guess my question is because technically that is part of the potential extension of Richmond. And I'm concerned about what the municipality may have in mind for traffic calming in the area should the Skydev development go through, which would actually probably lead to additional utilization of some of the other building lots that are around. Has there been any consideration done on traffic calming?
Oh, go ahead.
Thanks, Madam Chair. So regarding the road allowance, there's no intention of the municipality to open that road allowance as a public road. There is an intention of having a walkway for pedestrian use on what we still own, for that the municipality still has care and control of, not necessarily where the easement is. Having some knowledge of this scenario, I don't know 100% why council chose to grant up Part 1 as part of an encroachment, but not grant Part 2 and only grant an easement there. But I'm going to speculate that there had been 2 encroachments that they resolved as part of a previous file, or however you want to call it, situation, which with 2 properties. And that's where the Part 1 was granted. The Part 2, my assumption would be that they were okay with the continued use, but not having not selling that piece of land to the landowner. So they can continue to have their driveway on that property, and it allows for the garage to continue, but it doesn't necessarily allow any new things to take place. But I'm not aware that we're thinking about canceling that easement or doing anything in that regard. However, I understand that the retained portion of the road allowance is intended to be kept as retained and could be utilized for public access from a pedestrian perspective. Those lands aren't probably the best to have a road because they only join two non-through streets. And in terms of traffic calming for Skydev, that application doesn't have that level of detail within it at this point because it was only a zoning application and it is under appeal. So we haven't been looking at things like traffic calming or anything like that because this will be a dead end. It's still going to continue to be a dead end road. It's not likely the traffic will go much beyond this particular property as the entrance was proposed fairly close to this property across the street. If that helps answer your question about the future intentions.
Okay, thank you, Denise. Any other questions from the committee? You've got yours answered? Okay, thank you. Is the applicant or their agent here for this application? And do you wish to speak to the application? Please state your name for the record before beginning.
Hello. Good afternoon. Okay. Good afternoon. My name is Greg Barch, and I'm the owner of that property. So regarding that property, there is lot 1, part 1 and 2, because the house was built in 1909 and was built on the road allowance. This is why was first was taken. Somebody fixed that problem long time ago. So what I would like to do in my house, I have existing addition, 1 story. I would like to make a 2nd story. I'm not changing the footings. I'm not changing existing house. I just want to make the addition on the 2nd floor. And porch, I have a front porch, which is closed porch. And I would like to change it to open porch, wrap around the house with nice wood details. So that's what I would like to have it in my house.
Okay, thank you. Does anyone have any questions? No? Okay, thank you.
Thank you.
Anyone else wish to speak to this? Okay. Margaret, can you please provide us with the suggested decision and conditions of the, oh, sorry.
Thank you, Madam Chair.
Sorry, Madam Chair. I understand that the agent was on the line too. I'm not sure. Can you just verify if he needs to add anything?
Claire, you can unmute and speak now.
Yeah, I have nothing to add. It's been very well presented.
Okay, thank you.
Thank you.
All right, Margaret.
Okay. So with respect to the recommendation, it is that the committee grant the minor variance to permit the development of the lands, subject to the condition again that the proposed addition be substantially in accordance with the site plan in the schedule and drawing that's in the decision, which matches what was in the report. The decision also does clarify the variances.
All right, thank you. I will now call for a motion on the decision as read by the Secretary Treasurer, Ed, seconder, Lynn. Any discussion? Seeing none, I'll call for the vote. All in favor? Thank you, that is passed. Oh, I forgot. I'm supposed to get you to let them know what the process is, and I forgot that for the first one. I don't normally chair the meeting, so bear with me.
The process is that the notice of the decision will go out and there will be an appeal period before the variance comes into force in effect, if provided here.
And that's also for the first one that we approved as well. Okay. We ready? This is application B14-2022. This is a meeting of the Committee of Adjustment to consider an application for consent of a new lot under Section 53 of the Planning Act for lands known as 065199 Fourth Side Road, St. Vincent in the municipality of Meaford. The requirement to hold this meeting is that there must be at least 14 days notice as prescribed by the Planning Act. Margaret, can you please confirm that public notice was provided at least 14 days prior to this meeting?
Yes, notice was given on August 8th, giving more than required 14 days.
Thank you. Can you please summarize the application and provide us with any comments that have been received concerning this proposal?
Certainly. Application B14-2022 proposes to sever a vacant lot from the 20.5 hectare property. The severed lot would be 6.26 hectares with an existing dwelling and have 206 meters of frontage on Fourth Side Road. The retained lot would then be 35.2 hectares with 469 meters of frontage on Fourth Side Road. Comments with no concern or objection were received from Historic Southern Métis and with recommendation from Grey County. In summary, noting that it must be ensured that MDS 1 setbacks can be met for the third existing manure storage location. Comments should be received from the Conservation Authority. Should the applicant seek to enter or destroy trees, the applicant should consult with the County Forest Management Bylaw, and provided not a set of comments are received from GSCA and that MDS is met, County Planning staff have no further concerns. Enbridge Gas also noted any service relocation would be at the cost of the property owner, and gas services, if required, needs to be requested. And comments received, I believe just today from the Conservation Authority, indicate that they have no objection to the proposal for the described consent as it does not impact any regulated areas, natural hazards, or natural heritage features, but they do note any future development within the retained parcel will need to be directed away from hazard areas, and if located within the interference area of the wetland or regulated area, a permit from their office would be required. And they do recommend contacting the Ministry of the Environment, Conservation and Parks should either bubbling or eastern meadowlark be encountered prior to development occurring.
Thank you. John, are there any other additional comments?
Can you hear me?
We can hear you.
Okay, yes, no, I have no additional comments.
Thank you. Has each member of the committee visited the subject lands, and does any member of the committee have comment with respect to their site visit or with respect to the application?
Just a very minor point, but there seems to be a discrepancy in a number of cases as to the size of the retained lot. In terms of some cases, it's listed as 35 hectares and then 14.26 and
Yes, sorry, Denise.
Thank you, Madam Chair. I think the notice has the discrepancy. I think you can rely on the staff report.
All right, thank you. Any other comments or questions? Is the applicant or their agent here for this application? And do you wish to speak to the application? Please present your name for the record.
Wonderful. So I'm Liz Buckton, and I'm a registered professional planner. And I've been working with the landowners, Spud and Fran Falls, regarding this application since late 2021. They have been going through an estate planning exercise, looking at their land holdings and considering the fate of those land holdings with respect to their future children or their children in the future. So I think what I would like to do at with the committee's support, is just to provide a very brief confirmation just around the sizing and the nature of the application. And I understand that there has been some discussion in the neighborhood as well around the nature of the application. And so I just hope to make a couple of clarifications just relating to those comments that are kind of floating around through the grapevine. So first off, as staff have noted, the application is for severance. The intention is to split the existing 50-acre parcel into two pieces. The severed parcel would be approximately 15.5 acres, and that will include the existing house and outbuilding that is there today. The retained lot is the vacant parcel, and that would be approximately 35 acres. And I think maybe that's where the discrepancy came from rather than hectares. And so that property is vacant. There's no intention to build on that property right away, but there is the anticipation that at some point in time in the future, a dwelling would be located there. And just in terms of evaluating the application for consistency with the policies, we wanted to ensure that a building envelope does exist on that property outside of any of those environmentally protected areas or minimum distance separations from barns. So the properties are designated rural by the applicable official plans, and those policies do allow for limited residential lot creation, non-farm lot creation, and farm lot creation as well. Those permissions have been addressed in the planning justification report that has been submitted along with the application, and the various technical items have been spoken to individually within that report. Those matters include access, servicing, minimum distances from nearby livestock operations, policies that have regard for environmental features on site. And in this case, there's a unique area of mapping that applies to the lands within the county official plan that I'd like to speak to. So within that County of Grey official plan, they have incorporated provincial mapping around potential shale and bedrock resources. And so that typically applies to locations where there is shale or bedrock within 8 meters of the ground surface. And those resources would be prioritized over other uses of the land because they are finite and they're fixed in location. So one of the elements of this application was going through to evaluate if the resource as exists on this property has any viability for extraction, because if there were viability for extraction, that would take precedence over other uses. The landowners engaged a professional geoscientist through GM Blue Plan Engineering, and they've carried out a review of the site based on their understanding of all of the licensing considerations that would go into an extraction operation if it were to occur on site. What they have advised is that extraction on this parcel would be not viable based on a number of different factors that have been outlined within their report. But considerations, for example, include depth to water table, the sizing of the parcel relative to setbacks that would be required for an extraction area, and also kind of the existing lot fabric, which does include some other dwellings and residential properties in the nearby area that could potentially be sensitive receptors if extraction were pursued. And so just in terms of the clarifications that I noted, I just wanted to make it very clear that there's no intention for further subdivision of the lands. The policy does not permit that further development of the lands. There's very, very stringent policies around rural subdivisions now. You really only see those being considered in the case of a resource recreational type of use. So your resorts or golf courses relating to views, vistas, and kind of those natural recreational areas. So there's no intent there. It's simply to split the lot into 2 parcels. And then there's no intention to establish a quarry on site. So as I noted, the evaluation regarding those shale and bedrock resources was completed, and that does identify that extraction on this property is non-viable. I would say that mapped resource area, potential resource area, does extend beyond this property to the north. And so I can't speak to what other landowners may have in process or consideration. I think if there were any kind of land use proposals on adjacent lands, they would need to go through a similar exercise to evaluate viability for extraction as well. But that's not an intention. So we're looking to split just into 2 parcels and no quarrying on site. And I think beyond that, certainly I've tried to do my best to address everything in the justification report provided, but I'm certainly happy to address any questions that arise from the committee or looping back once the public has had an opportunity to speak as well.
Thank you, Liz.
Thank you.
Are there any questions from the committee? Lynn?
Through the chair, what if some of the parameters on the resource extraction changed? Like what is probably the most fluid parameter?
So I think probably depth to water table is one of the key considerations there. I know that I referenced that and spoke quite a bit about that in the report that was received from Champlain Plan. There are quite stringent rules about extraction below the water table, and being that we've got clay soils and wetland feature on site, I think it's understood that there will be a fairly high water table to contend with on the property, maybe not at the top where the house is right now, but in that lower area. And so I think when you factor in, it's really kind of about all of the elements and how they layer on each other. But I think that water table and the intersection with the wetland on site would be a key consideration to reduce that liability for extraction. And just the volume of resource as well. Like a licensing application is not a simple, easy, or inexpensive process. So you really have to have enough of the resource there to make it financially viable to pursue as well.
Thank you.
That answers your question then. Any other questions from the committee? Okay, thank you, Liz. Anyone else from the public wish to speak, either for or against? Just come up to the podium, state your name.
Chairperson. So I am Stéphane Tremblay. I'm accompanied by my wife, my spouse, Carol Tremblay. We both live on the adjacent property west of the applicant's property, and that is subject to the application currently in front of this committee. We want to thank you for receiving our comments today and for considering our request. The title of our property is in our company's name, Ditram Holdings Corp. We are the sole shareholder and directors of the company. We plan to object to the severance application. However, in the interim, we are requesting an adjournment of at least 2 months so that we have adequate time to prepare a response. We received a notification on August 20th. After picking our mail upon return from vacation, we did not receive any supporting material with that notification. We received that supporting material after our request to the Secretary Treasurer on August 23rd, 2022. Upon receipt of the notice, we contacted our legal counsel, the retained planner, and the engineers who have been helping us with the issues that we'll be outlining in a minute to provide us with further advice on the application. None, of course, are able to meet our deadline because of August 31st, because other matters take priority, and also holiday schedule personnel are not available. Among other issues, there's a surface drainage issue between our property and that of the applicant lot and the one that's in between that needs to be resolved. We had commissioned a drainage study from an engineering firm in December 2021 when we first became aware of the intent of our neighbor. And the readings, the topographical reading for the study were completed in June of this year because of the scheduling and the workload of the engineering firm. We anticipate the report in the next few weeks. The drainage study will likely impact, and we hope, benefit all neighboring properties. We believe it is important that the committee have the result of that study to assist you in considering whether to grant consent or not. The application also raised some complex issue, which in fairness requires a reasonable amount of time to obtain professional advice on. Also, given that the applicants have been preparing their application for a number of months, fairness also dictates that we be given additional time to prepare our case. Further to our request for an adjournment, I'd like to outline below our general reasons for objecting to the severance. The application, in our opinion, does not conform to the official plan as it endangers our agricultural operation and those of the farms around us. The original MDS calculation that was referred to by the Secretary Treasurer did not at first take into consideration our plan for a chicken barn on the southeast corner of the property, which is the only place where we can put a chicken barn at this time, because we have a long 100 acres. We notified the municipality of this plan at the time of the NDS study back in December. And we have submitted now to the municipality the plans for the barn. And those plans are dated back to 2012. A further MDS calculation is required in this case. There is a title issue as well between the applicant and us in respect to the western boundary of our respective property, and that may be at the source of the discrepancy in the application. This also needs to be resolved before the process can proceed. The water table, in our opinion, and by the way, our well, which is 250 meters from the western boundary, is at 182 feet of depth. That's where the water is not adequate to sustain another potential residence. We've commissioned a water table study, which we anticipate to receive the report shortly, and we will share with you. Also, there's not sufficient and adequate infrastructure to sustain further growth in our area, and we need some time to be able to bring you the facts on that front. We are awaiting reports and counsel from our advisors, and we regret that we cannot provide further information at this point because of the short notice, and we're therefore asking for the 2-month adjournment. We respectfully submit these comments to your attention and for your consideration. Thank you.
Thank you. Is there anyone else that wishes to speak? Yes, sir.
Thank you, Madam Chair. And members. My name is Peter Johnson.
I think, does he have to push the button?
Is that better?
Yes.
Thank you. My name is Peter Johnson. I live about, boundary-wise, about 200 meters from where Bud and Fran live. I bought the property, my wife and I bought the property in 1989. Excuse me, we built in 1997 and we spend about 40% of our time there. It's 60 acres and it's on the west side and also on the north of Side Road 4. I'm not commenting on the merits of this application, but I would like to comment on the process piece, the request for an adjournment in 2 areas. Firstly, I guess the 2 areas being fairness and the second area being procedure. In cases like this, especially for committees of adjustments, it is a very difficult process when you have to adjudicate between neighbors who may not see the same way and people you know. That makes it more difficult, I think, than other types of inquiries or decision-making bodies within the community. That's why I think fairness and the perception of fairness, particularly the perception of fairness, is very important in reaching a decision. Stefan has noted that he needs more time to have his case heard. He needs to exercise his right to be informed by counsel or engineers what his rights are, what the information is, so he can present a full case. I mean, I think that's pretty basic in terms of a fair process. And given in this case, if I am correct, there's been no adjournment yet. So to offer one adjournment is not unreasonable, particularly when it's a matter that's under dispute, obviously, and between neighboring properties. I think what has to be remembered on the fairness issue is not the decision that's made, but how the decision was made. And if someone can, I mean, the ideal situation, if someone can walk away and say, look, I didn't get what I wanted, but I did get a fair and full hearing. That's great. That means the process has worked. So those are my comments on why it would be fair, I think, in this case, to give a reasonable adjournment to allow him to seek advice, which I think is probably his right and Carol's right. My second point is on procedure. If this committee were to decide not to grant the adjournment, to grant the consent, and the matter was appealed before the Ontario Land Tribunal. Undoubtedly, one of the grounds would be a lack of procedural fairness based on the fact no adjournment was granted. Pretty clear that that's what a lawyer would do in these circumstances. Now, it seems to me that for everybody's benefit, if the adjournment is granted, that grounds of appeal effectively goes away. Now, if the tribunal decides that there was in fact no procedural fairness because of the lack of an adjournment, they'll send it back for rehearing. That will add a considerable amount of time and difficulty for everyone, including the Falls, who will have to effectively have this matter reheard. Planning department will have to do more work, and you, the Committee of Adjustment, will have to sit on this matter again. So I think that there's a great advantage to everyone in granting the adjournment and allowing the full case to be made by both sides. Those are my comments, and thanks very much.
Thank you. Any other comments?
Do I need to push it?
It's on now.
No, it's on. Good.
Yes.
Thank you. Thank you very much. My name is Joanne De Laurentiis, and I'm Peter Johnson's wife. So I live in the property that he has described. When we bought the property, it was actually a severance of 60 acres from the adjoining farm, which had been in the same family since, I think, the beginning of time when these lands were granted back in the day. And one of the main elements that was drummed into us when we bought that property was that we would not be allowed to sever it, that in fact what we should do with it would be to restore it to its perhaps not to its original state, but close to it. So we were granted leave to build a house, which we did do. But we also have been reforesting it over the 25 years that we've, since we built the house, and the 33 years since we've owned it. We've planted 16,000 trees, and we've let except a small section around the house, rewild itself. Because that was the intention. So really, I speak to the merits of the application, which is the intention of this municipality, it seems to me, had been to encourage owners of property in the area to allow the land to rewild and not to continue to subdivide. So I hope that you will take that point into consideration. Thank you.
Thank you. Anyone else? Seeing none, oh, sorry. Yes, if you could state your name, please.
I've been muted. Was there a question for me?
I think it's John Olding here. Can you hear me?
Yes, could you state your name, please?
My name is John Olding, and I'm a neighbor of the applicants, and I just would like to address a few comments.
Go ahead.
Thank you. Again, just acknowledging that the applicants are neighbors, very nice people, and I do wish them well in their estate planning. I just have a couple of concerns I'd like to bring forward. One is in December, I was invited by a planner to provide an information request regarding my livestock facility on my property. And at the time, I wasn't aware that was regarding this particular application. And I did provide the information that was requested. And when we bought our property, one of our intentions down the line is to activate this livestock facility that we have on our property. And I wanted to make sure that this severance request doesn't in any way impede that from going forward. I never did receive any reply back as to whether it would or would not. So I would like to get clarification on that. As a larger issue on the application, when we bought this property 3 years ago, we had understood that there was a key bridge that's very close to all of our properties would be made available to us. And we have since learned that that particular bridge is at some point in time either going to be closed or no longer maintained by the municipality, which means that we won't be able to get snow removal and a bunch of other considerations. And I'm just concerned that any further severance of properties is going to make it more difficult for us to use that bridge, given that it's no longer being maintained by the municipality. So I would just like to have, only because I learned of this application just a short while ago, a little bit more time to consider this and anything else regarding this application, just to make sure those concerns and others are addressed. So that's all I have. Thank you.
Thank you. Denise?
Just as a point of clarity, clarification, Madam Chair. So the speaker's property was part of the MDS study that was completed by the municipality in the winter. However, because the response took a few extra days to be received, from what I understand, and I didn't have any overlap between Kirsten and myself, or Kirsten and by myself, but what I can see is it appears that she did a best efforts estimation. And when I look at the actual response that the property owner provided, there was no difference in impact. I think that the MDS review that was done at the time would be sufficient. So that is of no concern to staff, at least.
Thank you. Okay, I am going to call on Ms. Buckton if you would like to speak to some of those points that have been raised.
Thank you, and I'll do my best. So the notes that I've made, so firstly, just regarding livestock facilities at MDS. So I think this might pertain to the Tremblay property as well as our last speaker there. I just wanted to note that minimum distance separation calculations, they're not directly reciprocal. So the setback that a new lot has to keep from a barn is greater than the setback that a new barn has to keep from a lot. And so the calculation itself favors a farmer and allows also for expansion of existing operations. So in the case where, as the last speaker noted, they are really looking to lean into that livestock use and perhaps expand that use. My suggestion would be that, we meet MDS calculations now. Those calculations do to favor and do some degree of grandfathering for an existing facility to allow for expansion. And so, typically the MDS calculations do favor the farmer to facilitate that expansion. So it's not a direct apples to apples setback comparison. So I just wanted to note that because I think it is useful and hopefully would alleviate some concern regarding surrounding livestock uses. With respect to the comments that were raised by the Tremblays, and thank you, I appreciate it. Sounds like they've done a lot of legwork regarding their property and the general area. I guess I would note there, regarding conformity to the official plan, I would say confidently, in my professional opinion, it does comply with the official plan and the provincial policy statement is consistent with those requirements. With respect to the MDS, I guess we're really trying to nail down setbacks on a first come, first served basis to some degree. And it's done that way to protect the interests of landowners and applicants in moving forward, together with that non-reciprocal MDS setback. So I think, certainly if there is an additional manure storage, which I understand there may be a calculation required there, I would perhaps query staff if that calculation for the additional manure storage has been completed. I don't know if that's something perhaps through you, Madam Chair. If
Denise?
So there was a couple of things to note. So I'm not 100% sure. The county comments noted a manure storage. They had a manure storage comment. And from what I can see in the file, that is because the MDS calculations were to the lot line. So there was a manure storage facility that slightly, the arc, if you will, falls just over the lot line at the very furthest west boundary, where probably you wouldn't be able to locate a house anyways. And you'd have to be at least to have side yard setbacks and all of that stuff. But we do recognize that it's to the lot line. So basically the arc was assuming that the entire lot was something that we wanted to understand whether there were barns influencing it, not necessarily where the house would be built. So that's why on that, if you look at the drawing that was included in your package, there's an arc that just goes over the lot line. So that's I think that's the MDS point about the manure storage. We do understand that, yeah, maybe people have some intentions about putting a new facility in and things like that. And if they already have a livestock facility, MDS has some development rights kind of in there already. So if you're expanding, it works out differently than it would be if you were just starting from scratch. So from what I can see in the file and also in my own estimation, the neighboring property that already has a barn expanding, it makes much less of an impact to them than if they were starting from scratch.
Go ahead, Liz.
So I think that was. So I guess my thinking there is, we've identified that there are livestock operations and manure storage is nearby. Those setbacks encroach in a very minor way along the western boundary. But generally those setbacks would apply to the dwelling on a property of this size. Within the MDS guidelines, there are different tools and rules that we can apply in different circumstances. And so in this case, I think we really would be looking at where a future envelope would be located for a future dwelling and ensuring that that meets setbacks from adjacent livestock facilities at that point in time as well. There is a requirement within the MDS guidelines that lots created after 2017 have to go through an MDS calculation at the time of building permit on those lots. So that review will have to be undertaken at the time of future building proposal. Regarding that narrow parcel to the west, yes, we've been looking into that as well. The Falls have engaged their lawyer around that narrow parcel just to try and understand the history related to it, to go through and consider the process that would be involved to consolidate that parcel in with either their parcel or the abutting parcel on the other side. They have reached the point in those discussions with the lawyer where we understand there's quite a number of steps that have to happen in order to bring those lands into proper ownership of the heirs so that they can then be transferred. And so we decided to proceed with the application at this point, just recognizing that once we've detailed out that whole to-do list that goes along with acquiring that parcel potentially, there might not be the utility there to really balance out the expense of that process. Having worked for the municipality previously, we certainly have dealt with quite a number of those forgotten parcels. And typically that is kind of resolving those ownerships, bringing them into an assessed parcel status requires work both from landowners, surrounding landowners, and the municipality in often cases to kind of bring all of those pieces together. So I would agree that there's some additional work to occur relating to that narrow parcel. I would perhaps disagree that, I don't necessarily think that's material to whether the severance is approved or not. The way that we have structured the severed and retained parcels would allow for future merge of that narrow parcel to the west in with the retained parcel at some point in the future, if we do end up making it through to the end of that acquisition process for those lands. And that's been an intentional choice to designate the house parcel as the severed, to allow for that merge to happen at some point in the future if necessary. And then I guess just regarding the comments regarding procedural fairness and then deferral, I think generally this application has been in process for a while. I hear what the neighbors are saying. I think the fairness does have to go both ways as well. And just planning out to stay clear in terms of the timeframes that apply to these applications in terms of notification and how documents are shared. And also those legislative timeframes do now come with financial penalties or will come with financial penalties to municipalities
municipalities processing of applications doesn't happen within the legislated timeframes. That said, I suppose perhaps I would ask at this point if there is the potential for a short recess, that I could discuss that option with my client. I think that some of the concerns that were raised by the neighbors perhaps have merit. They may want to consider that as an option, but I would need an opportunity to briefly chat with them to confirm if that approach is something that they would be interested in on a voluntary basis, depending on how the committee feels about that element as well.
Okay, thank you, Liz. Does anybody have any questions with regards to this? And how do you feel about a short recess?
Just
Terry?
before we discuss the temporary adjournment, can you address the drainage concern that was expressed?
So I'm not aware of. I'm not aware of what the specific drainage concern is. I have not been advised of the nature of that. My thinking is that kind of the west end of that property, you've got the wetland, and there's a fairly narrow area of land between the wetland and that narrow parcel at the west end of the property. It is fairly low lying, and so I don't know if that's perhaps kind of the area that another area.
Geographical study that the land plane goes to the corner of my property.
Okay.
And there's a drainage issue.
Okay. Okay, and so I think it sounds like there's perhaps then a broader issue with respect to drainage. My thought there is I don't necessarily, again, think that it pertains specifically to the severance application. And so, yes, there may be additional work and negotiation that has to happen around finding solutions for a drainage issue being experienced. But I don't think that that necessarily relates to whether these lands are held in two parcels or one parcel. I think that we would have the ability to deal with any issues or have those negotiations independent of this process. So from a scope perspective, I think that's probably perhaps out of scope with respect to this decision at this time.
Thank you, Ed.
Yes, one gentleman mentioned that they were considering building a barn on the adjoining property. And so if the severance is granted and he puts up a barn, then whoever builds the house on the severed property will have to keep MDS from the barn, correct? Okay, thank you.
Any other questions for Liz? So I know, can we take a short recess? What's the wish of the committee? Sure. How long do you need, Liz? 5, 10 minutes? 10, we'll just take a short 10-minute recess then. Okay, thank you.
Thank you very much. I really appreciate the opportunity for a short chat there with the client. So what we've discussed, I think certainly from that procedural fairness perspective, we've certainly submitted everything required, followed the associated timeframes, but can appreciate that sometimes, especially where there's multiple factors with an application, moving parts to be considered, that the neighbors might like to have a little bit of additional time. We do have some time considerations here just with respect to the fact that we are hoping to wrap this up within the calendar year in terms of the severance and related zoning amendment. And we've got an election to work around in terms of council timing. And then also winter is coming, which can affect surveying scheduling as well. And so what we would suggest is that, a number of the matters that I've raised are, in my opinion, outside of the scope of this particular application. But we do think that a minor deferral would be appropriate and fair to allow for further discussion with the neighbor. And so what we would ask is for a voluntary deferral of 1 month. And I think recognizing that 2 months was requested and there's probably some report timing wrapped up in that, what I would suggest is that there would be a willingness certainly to have a conversation with the municipality or with the landowners or perhaps together to talk about the elements of importance that may be pertinent to the application as opposed to more broadly relevant to the area over the period of that next month. So I think that's where we've landed, and certainly at the committee's discretion, they could consider that voluntary deferral of 1 month, or as you see fit with respect to the request from the neighbors for 2 months as well.
Thank you, Liz.
Okay, thank you.
All right, back to the committee. Terry.
I'm in agreement with a voluntary 1 month deferral. When you add in the additional 20 days of the appeal period, we're essentially talking at 50 days potentially anyway before a final decision is reached. I think to extend it to 2 months plus the 20 days is a little bit too long in this case.
Okay. Would you like to make that a motion?
Perhaps you want to have more discussion first.
Sure.
No, I'm in agreement with Terry.
I could see him shaking his head, so Lynn?
I'll go along with that. I'll make a motion if you like.
Okay.
I move that we adjourn this for 1 month.
Second by Terry. Any other discussion from the committee? Seeing none, I'll call the question. All in favor? Okay. So then the process now will be in 1 month. It comes back before the committee, which will be our next meeting, which is September 28th. It sounds very fallish. Okay. All right. I think that's any other business for the committee? Seeing none, I'll adjourn the meeting. Thank you, everyone.